used for. Exactly. It was his handling of the recusal motions, like the way he inserted new facts into the order. Like if he had, the second he'd gotten those recusal motions, like Weinstein said, he should have sent them out to another judge, and he didn't. And reading this ruling, you can tell, like if he had sent those out to another judge, he wouldn't have been recused. But sorry, I hit a little. I was actually in court in LA federal court, and I glanced at my phone and saw this come up, and I was like, oh shit. I had to like run out of there, and all this stuff was going on. I saw this friend who wanted, and I was like, yeah, I gotta go. It was kind of frantic. But yeah, findings of fact. These recusal, and this is Judge Krause's order issued today. She said these recusal motions arise out of a multi-defendant prosecution brought by the Fulton County District Attorney's Office alleging gang activity and associated crimes. Although there were 28 defendants named in the indictment, only 6 were being tried as of June 7th, 2024. The motions to recuse all arise from the same circumstances related to state's witness, Kenneth Copeland. I hate how there's a comma there because there's more than one state's witness. So anyway, on June 7th, 2024, the state intended to call Kenneth Copeland to testify. Prior to his testimony, counsel for Mr. Copeland, Jonathan Melnick, appeared and indicated in open court that Mr. Copeland did not wish to testify and intended to invoke his Fifth Amendment privilege against self-incrimination. Judge Glanville brought Mr. Copeland into court and discussed with him the effect of an immunity order Judge Glanville had entered that granted immunity to Mr. Copeland. Judge Glanville specifically advised Mr. Copeland that if he invoked the Fifth Amendment and refused to testify, the state would ask for Copeland to be held in contempt and jailed. Judge Glanville also advised that, if asked, Judge Glanville would jail Mr. Copeland for refusing to testify. After the discussion, Mr. Copeland spoke to his attorney and then indicated he would testify. Once called, Mr. Copeland was asked to specify his age, and instead of answering, he stated, "I plead the Fifth." Judge Glanville excused the jury and then advised Mr. Copeland in open court that he was in contempt and ordered him jailed until Monday, June 10th, 2024, at which time Judge Glanville told Mr. Copeland they would revisit Mr. Copeland's willingness to testify. Mr. Melnick spoke to Mr. Copeland and then reiterated to the court that Mr. Copeland still intended to invoke his Fifth Amendment right if called as a witness. Judge Glanville indicated he would revisit the issue with Mr. Copeland on Monday, June 10th, 2024 at 8:30 a.m., and court was adjourned for the day. On June 10th, 2024, at approximately 9:10 a.m., Judge Glanville met with counsel for the state, Adrian Love, and stand-in counsel for Mr. Copeland, Kayla Bumpus. The meeting took place in Judge Glanville's chambers. Counsel for the trial defendants did not participate in the meeting and were not aware that the meeting was taking place. The transcript reflects that Ms. Love told Judge Glanville that she wanted the meeting to both impress Mr. Copeland upon Mr. Copeland the risks of refusing to testify and allow Mr. Copeland to ask questions before he testified. Ms. Love also expressed concerns to Judge Glanville about Mr. Copeland's representation. Ms. Bumpus, Ms. Love, and Judge Glanville also discussed the scope and the effect of the state's grant of immunity to Mr. Copeland. Mr. Copeland was then brought to Judge Glanville's chambers where he spoke with and asked questions of Ms. Bumpus, Judge Glanville, and Simone Hilton, counsel for the state who had joined the meeting. During that time, the state advised Mr. Copeland that he would remain in custody until the conclusion of the trials of all defendants in the case, not just the 6 currently on trial. Judge Glanville discussed OCGA 24-5-507 with Mr. Copeland and his rights and responsibilities after a grant of immunity. Mr. Copeland spoke privately with his stand-in counsel, Ms. Bumpus, and then advised the court that he would testify. After the meeting and immediately before Mr. Copeland was brought out to testify, defendants Williams' lawyer, Brian Steele, advised the court that he was aware of the in-chambers meeting that morning. Mr. Steele objected to the ex parte meeting, and a lengthy colloquy occurred between Mr. Steele and Judge Glanville, in which Judge Glanville inquired how Mr. Steele became aware of the chambers meeting. Mr. Steele declined to reveal the source of his information, and Judge Glanville held him in contempt, though Mr. Steele was allowed to remain in the courtroom on behalf of his client Defendant Williams. She skipped over the fact where he was actually held in custody for, it was like 40 minutes that he was back in the holding cell, which is crazy, but that's fine. That's still an accurate conveying of what happened. And Judge Krause's order continues here. Ultimately, Kenneth Copeland did testify on June 10th, 2024, and was later released from custody. The next day, Judge Glanville issued a show cause order requiring everyone present at the ex parte meeting to appear in show cause as to why they should not be held in contempt for disclosing information about the ex parte to defense counsel. An amended show cause order was later entered setting July 1st, 2024 for an in-camera review of the transcript of the ex parte meeting. The first motion to recuse followed, filed by DeMonte Kendrick on June 12th, 2024. Mr. Kendrick's motion seeks to recuse Judge Glanville for his involvement in the allegedly improper and coercive ex parte meeting with the state. And notice how she included allegedly. And she never goes on to agree with those findings that it was improper and coercive. It was just everything that happened after that. It's pretty fucking interesting. But on June 14th, 2024, Judge Glanville denied the motion. Judge Glanville determined the recusal motion was timely, supported by an affidavit, and, quote, on cursory review, quote, contains assertions of facts to support the allegations of bias and impartiality. However, Judge Glanville ultimately determined that because there was no way to verify the veracity of the information contained in the affidavit, and there was no actual evidence of the extent of the discussion during the in-chambers meeting, the affidavit was legally insufficient, and the motion to recuse did not require a referral to another judge for consideration. So on June 14th, 2024, Caleb Bumpus files a motion to quash the show cause order to recuse Judge Glanville or to recuse Judge Glanville from presiding over any contempt action against Ms. Bumpus resulting from alleged disclosure of the ex parte meeting. On June 17th, 2024, Jeffrey Williams filed his motion to recuse Judge Glanville. Divorced from its hyperbole. Yes, seriously, guys. And this is, I love this judge. She obviously hates Judge Glanville, but yeah, she can read that motion and be like, calm down, guys. Divorced from the hyperbole. Mr. Williams' motion and supplement also seeks to recuse Judge Glanville because of his involvement in the ex parte meeting, which Mr. Williams also alleges was improper and coercive. I want to read this footnote here. Technically, Mr. Steele's counsel moved to recuse Judge Glanville from further handling of the contempt action during the June 10th proceedings. However, the motion was made orally, and it is not before the court because Mr. Steele's contempt matter is currently pending before the Supreme Court. Another footnote says, although referred to this court for consideration, Bumpus's motion to recuse is both premature and moot because Ms. Bumpus has not yet been held in contempt and because on July 1st, Judge Glanville canceled the show cause hearing. So this is just DeMonte Kendrick's and Young Thug's recusal motions here. Mr. Williams' motion alleges both actual bias and the appearance of bias because Judge Glanville allegedly participated in the accusatory process when he met with Mr. Copeland, and Judge Glanville became, quote, embroiled in a controversy when he held Mr. Williams' lawyer, Ms. Brian Steele, in contempt. On July 1st, 2024, the day appointed for the parties to review a redacted transcript of the ex parte meeting, Judge Glanville announced that he was releasing the entirety of the transcript of the meeting and was taking judicial notice of and making a record regarding certain matters associated with the meeting. Most of what Judge Glanville relayed was a coalition of record evidence about the recent circumstances in the case. Judge Glanville also explained how he became aware of the state's request for an ex parte meeting. In addressing the circumstances of the contempt against Mr. Steele, Judge Glanville explained the court's purpose and concern in pursuing information about the security and confidentiality of his chambers. Judge Glanville advised that he had not yet instigated an investigation into surveillance footage, but had reviewed such footage for timeline and security. Judge Glanville then explained his view that the meeting was proper under Georgia law and outlined relevant law that supported his inherent authority to hold such a meeting. Judge Glanville maintained that no one gained a tactical advantage as a result of the ex parte nature of the meeting. Judge Glanville also questioned defendants' right to be present in the ex parte meeting because the issue under discussion was between the state and a witness who was represented by counsel. After making this record, Judge Glanville announced that the show cause hearing was canceled and that the recusal motions filed by Mr. Kendrick, Mr. Williams, and Ms. Bumpus were being referred for consideration by another judge in accordance with the Uniform Superior Court Rule 25.1 through 25.7. The motions to recuse were then assigned to this court for consideration. This is Judge Rachel Krause. Legal framework. We're getting into the heart of it here. Motions to recuse are governed by a specific legal framework outlined in Rule 25 of the Uniform Rules of Superior Court. A party seeking recusal must file a timely motion supported by an affidavit, quote, clearly stating the facts and reasons for the belief that bias or prejudice exists. The affidavit must be, quote, definite and specific and describe circumstances of extrajudicial conduct or statements which demonstrate either bias in favor of an adverse party or prejudice toward the moving party in particular, or a systemic pattern of prejudicial conduct towards persons similarly situated to the moving party, which would influence the judge and impede or prevent impartiality in that action. Bare conclusions and opinions are, quote, not legally sufficient to support the motion or warrant further proceedings. Once such a motion is filed, it is the duty of the assigned judge to temporarily cease to act upon the merits of the matter and assess the timeliness and legal sufficiency of the affidavit and alleged facts. If all three criteria are met, i.e. the motion is timely, supported by an affidavit, and the facts alleged might warrant recusal, another judge shall be assigned to hear the motions to recuse. When considering a motion to recuse, the assigned judge should be guided by Rule 2.11 of the revised Code of Judicial Conduct, which provides that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. The standard is objective from the perspective of a reasonable, fair-minded, and impartial person, rather than the affected judge or the interested parties. If a motion to recuse satisfies the three threshold criteria, the assigned judge must refer the motion for reassignment and may not, quote, oppose the motion. The judge whose recusal is sought may not respond to the motion or attempt to refute the allegations, which stand denied automatically, no matter how false or even defamatory to the judge. No matter how false or even defamatory the judge might know or perceive the allegations to be. A judge cannot become actively involved in presenting evidence or argument against a motion seeking his recusal without the defense itself becoming a basis for recusal. And these are quotes from actual previous case law. So, and this is funny because this isn't really in the recusal motions very much. This is kind of the judge coming up with their own stuff, I think. But here, Judge Glanville had previously announced on the record that the motions were timely and supported by an affidavit. Yeah, he screwed himself by saying that. In transferring the cases to another judge for consideration, Judge Glanville necessarily determined that the third criteria was satisfied, i.e. that recusal might be authorized if the facts alleged in the motion were deemed true. Yeah, that is what did when he deemed that, but then didn't recuse over. Therefore, Judge Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. Yeah, that's what he did. That's what screwed him over. It is worth noting that the court agrees generally with Judge Glanville's assessment of the propriety of the ex parte meeting. That just makes this recusal motion just all the more brutal for him. While the meeting could have, and perhaps should have, taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. However, in his order denying defendant Kendrick's motion and in the process of making his record on July 1st, 2024, Judge Glanville added facts, provided context, questioned the veracity of allegations, and otherwise explained the decisions and actions and argued why those actions were proper. This is so fascinating to me because the supplement that Brian Steele and Keith Adams filed after July 1st really did not look at that in the case law. It was just all about the transcript and all about the misconduct that occurred in this ex parte. And it's like, no, the judge found like a whole other reason after that, and like kind of goes into her own case law here. While it may be appropriate for the judge to disclose information relevant to his potential recusal. Such a disclosure must be made in a way that is as objective, dispassionate, and non-argumentative as possible, so that the judge is not reasonably perceived as a hostile witness or advocate. In presenting his record as to the recusal issues and in ruling on Kendrick's motion, Judge Glanville, quote, evaluated and accepted the truth of his own factual allegations, mandating the recusal. This court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motions were denied. But the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling of this case. I'm like, okay, I think this ruling tells us everything we need to know about what Fulton County Superior Court judges think of their arrogant prick chief judge. Like, I mean, seriously, this is bad for him.